Cromie and Kanssen formed a company to operate a cinema in London. They fell out, and Cromie cooked up a scheme with a man named Strelitz to pretend Strelitz had been elected as a director. They even forged some board minutes to that effect. Kanssen refused their demand that he resign as a director, so Strelitz and Cromie started issuing themselves shares so they could outvote him. He protested. The statute had a rule that if a director was appointed and there were irregularities in the appointment, the director's decisions were still valid. Cromie and Strelitz relied on this rule to overcome the fraudulent way in which Strelitz had been appointed. Lord Simons, however, said the provision was machinery to avoid questions being raised as to the validity of transactions where there has been a slip in the appointment of a director, and cannot be utilised for the purpose of ignoring or overriding the substantive provisions relating to such appointment. Cromie and Strelitz obtained further finance from Morris, who knew nothing about all the frauds and schemes. Morris was appointed as a director and allocated shares. Kanssen, meanwhile, was fighting on and proved that Strelitz was not properly appointed, and neither was Morris, and neither were their shares properly issued. Morris relied on the indoor management rule. Coming into the company, he was entitled, on his argument, to presume that things had been done in a proper and regular way. The court disagreed because he was not an outsider. By this point, he was a director of the company. Lord Simons said the indoor management rule was designed for the protection of those who are entitled to assume just because they cannot know that the person with whom they deal has the authority which he claims. It is the duty of directors to look after the affairs of the company, to see that it acts within its powers and that its transactions are regular and orderly. To admit in their favour a presumption that that is rightly done, which they have themselves wrongly done, is to encourage ignorance and condone dereliction from duty. Morris's appointment and his share issue were therefore held to be invalid. From this case we learn that directors are responsible for the internal management of companies, and so they cannot rely on the indoor management rule. They must make their own inquiries from within the company.